them to implement solid human resource and labor relations policies and practices. In particular, Kelsey focuses on avoiding or dealing with issues of unionization, unionized labor disputes, collective agreement negotiations, and working through the grievance process. Now, when an adversarial approach is more appropriate, Kelsey is also very proficient and persuasive advocate for both federal and provincial employers at all stage of the litigation process, whether it be administrative tribunal, grievance arbitration, civil litigation. He also has represented employers before the Industrial Relations Board, both in Canada and the Ontario Labor Relations Board, the Ontario Human Rights Tribunal, and has appeared at all levels of court in Ontario. So welcome, Kelsey. We're so happy that you're here with us today. And backed by popular demand is Mike McLellan. Mike helped us early on in one of our first expert series when companies were dealing with HR issues. Welcome back, Mike. He's an advisor to employers on a wide variety of legal matters, including collective bargaining, interpretation and application of collective agreements, employee discipline and termination, human rights, workplace violence and harassment, responding to union certification applications and related employer applications. He's an expert in the construction industry matters, the Labor Relations Act, and complaints under the Employment Standards Act. When matters progress beyond providing strategic and proactive advice, Mike successfully advocates for employers at the HR Tribunal of Ontario, the Ontario Labor Relations Board, private labor arbitration boards, the Ontario Grievance Settlement Board, the Ontario Superior Court of Justice, and the Ontario Court of Justice. He has provided sophisticated counsel to numerous private sector clients, as well as institutional and public sector clients, including municipalities, social service providers, healthcare providers, and facilities and crown corporations. So Michael, thank you so much for joining us as well. Why don't I ask an open-ended question as we head into the next phase of the pandemic? We've most of our, I should say all of our companies have had restrictions lifted. We're now in stage 3. What are the key employment issues for business owners?
I'll kick us off. Thank you very much for that introduction, Todd. Very happy to be back. Sounds like both Kelsey and I have been busy. And we have particularly during the COVID period, and we keep being busy, because as you mentioned, the Ontario economy is reopening and businesses are reopening, and that comes with it a bunch of employment and staffing issues. And obviously what's coming along with that is returning the employees to work. But, understandably, there are certain obstacles getting in the way, maybe limited capacity of business, and maybe we can't bring everybody back all at once like we would want to. How do we deal with that? And on the flip side, understandably, we may have some staff who are unable or unwilling to come back. And we really have to take a look at how do we address those situations, and do the employees have a right to be off, or can we maybe get a little bit creative? And if we can't, what are the consequences of an employee who doesn't want to come back to work?
Very good. Kelsey, are you experiencing the same types of issues with employers now that we're a number of weeks in?
Yeah, I mean, as has been the case throughout the, what are we in, 5 months now of this pandemic, uncertainty is the name of the game as we move, on a day-to-day and week-to-week basis. And, there's not necessarily any blame to be laid, but it certainly is not an easy thing to be either an employer or someone advising employers, because the ground is constantly shifting under our feet. I think, like Mike said, it's a matter of looking at each circumstance in its own context, right? Whether you're an employer of 300 people or 30 people or 3 people, your specific circumstances are going to be different, as are the circumstances of each one of your employees. And so when these, kind of grand announcements are made, we're moving to phase 3, or there's an amendment to the Employment Standards Act, all well and good, but it doesn't necessarily mean that all of a sudden it's, an easy thing for an employer to sort out. And so that's been our job over these last several months, is trying to help employers figure out exactly how the latest change applies to them. And that's no different as we move into the next,
Yeah.
greater
You've,
phase of
yeah.
opening.
You've no doubt been very busy, and you're right. With so much uncertainty, each challenge, problem, question has to be contextualized. So I encourage those that are viewing today to put their specific questions to our experts, either via chat or in the Q&A. That both can be accessed at the bottom of your Zoom screen. Let's get to a specific situation. What are an employer's obligations, or what has to happen to ensure that they're compliant on, let's take an example, layoff extension, for example. You've laid somebody off in March or April. Conditions are such that you can't bring them back yet. What are an employer's obligations in a layoff extension? And maybe you can just flip it as well. On staff return, what are some of the key compliance issues?
Well, I can kick this one off, and Kelsey, please supplement if there's anything you think I miss. So back at the end of May, the Ontario government implemented a new regulation to the Employment Standards Act. And the advice I'm going to give, you have to take it along with all the information about layoffs I gave during our first talk, which I believe is still up on the Facebook
Yes, it is.
page that you can still.
That can be accessed at bramptonvot.com/expert series. Yeah.
Perfect, because layoffs are not entirely straightforward. But the Employment Standards Act was amended, had a new regulation enacted back in May that said that any employee whose hours of work were reduced or eliminated directly due to COVID-19 circumstances were deemed not to be on a layoff for purposes of the Employment Standards Act, but were deemed to be on a job protected leave of absence. And that was called the infectious disease emergency leave. Okay. And the infectious disease emergency leave was, or the regulation says it is in place for the entire, what's called a COVID period under the regulation. And the COVID period was essentially going back to, I think it went back to January, and the COVID period ends 6 weeks after the declared emergency in Ontario is declared to be over. We got that declaration on, I believe, July the 24th, which means 6 weeks after July 24th, or I believe, if my count is right, it's September 4th. That portion of the regulation basically becomes ineffective. Okay, so currently, if an employee is on what we would consider a layoff for Employment Standards Act purposes, it's really a deemed employment leave, a deemed leave of absence at law now. So what happens on September 4th, when the COVID period ends, is essentially it's not set out in the regulation, but we have to look at the act as a whole. And we did some work in our office to get information directly from our members of provincial parliament to get this direction, and from the Director of Employment Standards. Basically, under Employment Standards Act, the clock will start again on our temporary layoffs under the Employment Standards Act. And why that is important is that any layoff that is not a temporary layoff under the Employment Standards Act is a termination under the Employment Standards Act. And so what constitutes a temporary layoff is typically going to be a layoff of 13 weeks in any period of 20 consecutive weeks, or if certain conditions apply, so these will be kind of exceptional circumstances, 35 weeks in a period of 52 consecutive weeks. So I think that kind of addresses the first question. Kelsey, if I missed anything.
No, I think, I mean, and I presume, and I know from speaking with you that you covered the difference between, you know, a valid temporary layoff and constructive dismissal in the first session, right? So I don't want to get into that too much because obviously we're talking about the specific application of the Employment Standards Act regulations and so on. The only thing I'll add, and maybe a concrete example so that our viewers understand what we're getting at here, is the amendment to the Employment Standards Act said basically any layoff that happened between March 1st and July 24th, although at the time they didn't know it would be July 24th, was deemed not to be a layoff, but instead to be access to the declared emergency leave under the infectious disease emergency leave, sorry. So if you started a layoff at that point, you have a fresh clock starting on September 4th, as in your count down to those 13 weeks or those 35 weeks that Mike identified begins on September 4th. Now, the other part that Mike mentioned as we got information from the Director of Employment Standards is if you had someone on a layoff prior to March 1st, any weeks that they were not working during the COVID period, as Mike mentioned, do not count towards that layoff. However, any weeks prior to March 1st will count. So you don't get a fresh clock just because we had this intervening period, but if you laid them off on, I'll do February because it's easy for me to count those weeks, February 1st, and then, so that's 4 weeks there, and then you have this intervening period of 5.5, 6 months, whatever it ends up being. You don't get a fresh clock, but you start at those 4 weeks. So
right.
important to
13
know
minus
for
4, right? Yeah. Okay.
Exactly. Yeah, that's
good,
what you have
very
left.
good.
Yeah.
Great. Tell us more about return to work. What are some of the obligations there? Let's say you can accommodate one or two. Tell us about the obligations that way.
Yeah, I mean, it's a bit murky, right? Because we haven't dealt with this kind of situation before, and we do know that from an accommodation standpoint, if we're talking specifically about the duty to accommodate as it applies under human rights law, you know, the Human Rights Code in Ontario specifically for the purposes of our discussion today, you have to accommodate to the point of undue hardship. Well, what is the point of undue hardship? It depends on the circumstances. And now, instead of having, you know, one or maybe two employees who have unique circumstances, if we're talking about a family status issue or something like that, you may have two or, like 10, 15, 20, you may have them all in the same situation. And you have to look at each one in its individual context. Now, I think what happens as the biggest one and the biggest driver, I think, of schools being opened is that many employees have families and need something to happen with their kids to be to be able to be effective, right? Those of us who can work from home have been fortunate enough to be able to do that, but it's still not easy. And there are many people in the economy who can't work from home, whether they be frontline workers in any of the industries, healthcare, service industries, retail industries, and those are the industries that were hardest hit with this. So getting people back online is good. You know, there are so many different paths and approaches that we might end up taking. It's hard to cover it all in this time, but it's, again, going back to what Mike said at the beginning, that contextualized approach, and I think that was the term that you used, Todd, that's going to be important, right? You're going to have to look at what you can do in any individual circumstance, but also recognize that, you know, you may have some legal obligations, but you may also have some legal rights as an employer. And one of the things we talked about before we came on was about, okay, well, what happens when schools do open? And, you know, if it's optional to send people back, does that mean that an employee then has the right to say, well, I don't have care for my kids? Because that's what you could say now under the infectious disease emergency leave. If your daycare is not open or if you don't have care for your kids, you can avail yourself of that leave under the Employment Standards Act. Mike, maybe you want to jump in and kind of tell the people what we talked about, or Todd, maybe, I'm not sure, sorry.
Sure.
Yeah, it's tricky because what the Employment Standards Act itself sets out under the Infectious Disease Emergency Leave amendments is that an employee can access this job protected leave in circumstances including that they have to provide childcare for a child whose school or daycare is closed. I mean, there's a number of possible conditions upon which an employee can access the leave, and one of them is including but not limited to the schools or daycares are closed. And so it's tough to say whether an employee can necessarily access that leave of absence as a right once the school or daycare is open. That certainly would not avoid the issue of an employer's inherent and persisting duty to accommodate an employee for something like a family status accommodation. And I would just add one more thing with respect to accommodations to work, because we're talking about the Infectious Disease Emergency Leave, and that is a protected leave under the Employment Standards Act. The Employment Standards Act says when somebody is coming back from a job protected leave, they have to come back to their pre-leave job. And if that job doesn't exist, the job that is most similar to their pre-leave job. So that's just another consideration for employers when welcoming their staff back to work.
Mike, let me give you an example. So in that particular case, when we're welcoming someone back to a similar job or that job, what if, though, they say, I'd love to, Mr. Employer, but I think I can only do part-time for childcare reasons, whatever. Is there any, what's the employer's rights, obligations, if that is the response from the laid off employee?
Well, it's tricky and it really depends on the circumstances, like we've said a bunch of times already, and like you're going to hear from us a few more times. And to be frank, I've had clients who have come to me saying this exact scenario and they want advice on it, but they think, well, this is great because we don't have capacity to bring everybody back to full time. So sometimes that's a built-in solution right there. And that's fantastic. I would always suggest, setting out the terms of a change in the employment and doing it in writing and making sure that every side is in agreement and we get those agreements in writing. But then sometimes it can get a little bit trickier. Sometimes we have to, if the employer wants the employee to come back full-time and the employee is saying, I can really only make it part-time. Well, to me, then we have to kind of ask questions to see whether our duty to accommodate is engaged. And always remember that accommodation is a process. It's not an event, it's a process. So we have to take a look at what's going on, what are the circumstances, is accommodation warranted, and is it something that we can handle? If it's not an appropriate context for an accommodation, then we kind of have to look at whether the employee is really resigning from employment. If
Right.
An employer is saying, we're open, we need you to come back to work, and the employee says no, and they don't have a reason for it that would entitle them to a leave or entitle them to an accommodation, we may be looking at a disciplinary response for being absent from work, or we may be looking at treating it as a resignation.
Right. Now, Mike, let's extend to this. Maybe Kelsey, you want to jump in as well. So let's say there is a refusal to work. It's not for a reason of accommodation. It might be, and we've heard this from employers, a claim that they feel unsafe, that they're too nervous to come back. What's the employer's obligation, compliance requirements in that case?
Sure, and you know what, this was actually a perfect segue, because that's where I was going to go to build off Mike's comments, is that, the message for employers is you don't have to just accept somebody saying, I'm not coming back, or I'm only coming back under these terms, just because of all of the, surrounding changes that have happened with employment rights and legislation due to COVID. In this kind of circumstance, though, my thinking, and so I'm going to separate the professional and the personal for a second, because I don't think that you can really. We none of us like to make decisions in a vacuum, and with all of these variables floating around, I'm not going to fault somebody for personally saying, I don't think I'm ready to send my kids back to school, and therefore I can't come back to work, whatever. But that's separate from what your obligations as an employee might be, and there may be consequences, and people have to accept that. So in my view, professional view, that is, if somebody is saying to you, I just don't feel comfortable, but you as the employer can demonstrate you're following all of the protocols suggested, recommended, or required, depending on what industry you're in, as set out in the various guidelines and any of the regulations or orders that apply. The healthcare sector has various things. And if you can provide that necessary training for those people, then you are essentially in a perfect spot as the employer to defend your own position. As Mike said, are we then treating that as a resignation? Is it somebody who is essentially abandoning their job? And that's your defense to that. So playing it out, that employee says, I'm not coming back, I don't feel comfortable. We say, and we wouldn't say it right away, but we would say, hey, look, I get that you might have some misgivings, but here are A, B, and C about why those misgivings don't apply to our situation. And we're open for a reason. We're allowed to open, and we're allowed to open under these conditions, all of which we've met. So if you don't come back, we're going to have to consider you to have resigned your employment. Employee then says, this is constructive dismissal, or this is a wrongful dismissal, and there we go. So what we have to do then is defend our decision. It's almost looking at it from, not to digress too far, but looking at it from the kind of perception of how you would defend an occupational health and safety thing proceeding by saying, well, we've done our due diligence, we have everything in place. It was unreasonable of this employee to say, I can't come back to work.
Right. Yeah, very, very good. So it is very contextual, as you've said earlier. And your point, though, was that employers don't have to simply accept the response from employees. It is a process, both in terms of accommodation, it is a process as well in defending and saying, okay, your case with respect to being unsafe, are you aware that we're sanitizing at this frequency, that we have spacing, we have sneeze guards in place, etc., and that can perhaps help the employee to feel comfortable that their concerns have been allied, or you have a different conversation about resignation. Okay, so lots of different things to think about. Return to work accommodations, layoff extensions, how the clock is reset. What about, I know we talked a little bit about it, Mike, the Canada Emergency Wage Subsidy. There's been a few amendments to that, and I think we've got a deadline pending for it, a current deadline pending for it. Tell us a little bit more about the emergency wage subsidy, and perhaps some of your clients have had some experience with that. That might be valuable to share today as well.
Well, the best thing I can tell you about the Canada Emergency Wage Subsidy is talk to your tax advisor and your accountants about it. That is the gold standard of advice that I'm giving these days, particularly with the kind of new elements and factors that the federal government have introduced, and that the kind of rest of the government and frankly community are finding a little bit maybe onerous and complicated. So definitely contact a tax professional to get advice about that. Certainly, though, it can be a very useful tool for businesses right now. Providing some relief on the wages that are being paid to staff. It's important to understand what the wage subsidy can cover. It does cover wages, and that should be given interpreted broadly enough, basically to cover anything that you would pay to an employee that you would also have to make remittances to the receiver general. Salary, wages, commissions, bonuses, but also, something like pay in lieu of notice of termination. If it comes up, those are payments to the employee that attract those remittances to the receiver general. So it can be a useful tool in that manner as well. We've been told by the federal government that the wage subsidy plan is expected to, or will be extended until the end of December of this year. Make sure you understand how you are calculating your revenues for purposes of whether you are eligible to receive the wage subsidy in a given eligibility period. And in terms of when it can apply or to what kind of compensation it applies, someone like Kelsey or I can help, but for the hard math of it, please contact your tax advisor.
Right, very good. But thank you for that tip, though, that pay in lieu of notice is eligible for CEWS as well, the emergency wage subsidy. That may not be a known fact to many of our business folks. Okay, well, gentlemen, this has been helpful. There's probably many other issues. How about from your perspective, anything else you think Brampton businesses should know about this stage of the pandemic and this stage in employment law? We've covered a lot of things so far. Anything else?
I'm trying to come up with a gem, but maybe if I stall for a bit, Mike will have something pithy and wonderful to say. Really though, our message, Todd, as you identified, is as an employer, we've dealt with, and Mike and I are employers also, we've dealt with a lot of uncertainty, and a lot of it has had to just be, okay, roll with the punches, take it. Now we're coming back online. We're opening up to a greater extent, and for those of us who remained open during the time, we're seeing a kind of attempt to return to normal, and with that comes, your rights as an employer have not been extinguished or abrogated with respect to getting employees to work and to have them do what you need them to do. It just has to all fit in a different context, right? And so, the important thing from my perspective is don't just accept something, don't just reject something. Let's delve into what's happening, and then we can figure out whether we need to take a hard stance, whether we need more information or what have you, right? And that's essentially the way to do it right now. It's not as simple as just, I get response A, my reaction is B or C, right?
Yes, good. Anything further, Mike?
Yeah, to kind of piggyback on what Kelsey is saying, I think the key really might be flexibility when it comes to bringing people back to work. See if you can, I mean, it's not always possible, but because these are such extraordinary times, I would like it if everybody could be a little bit flexible and understanding on both sides of the employment relationship. Definitely very important to keep an ear out for all public health guidelines, and make sure those are being followed in the workplace. But one more thing is that because there have been so many changes to kind of the legislation, and we have principles at common law that we could say, well, in normal circumstances, we would expect the outcome of certain dispute to be this. And like I've said before, these just aren't normal circumstances. So there could be a lot of controversy and a lot of debate and a lot of uncertainty, even just about the state of the law in terms of how courts are going to make their decisions based on our individual fact scenarios. It's possible that we're going to see a whole lot of employment litigation coming out of the COVID period. But going back to the point I just raised about flexibility, if we can all be flexible and reasonable, hopefully we can avoid a lot of these disputes and, get everybody back to work in a productive and safe manner. That should really be the goal. And yeah, that's what we're all looking for and what we're all trying to do.
Well, thank you. That's very, very good advice from both of you. Kelsey's point, don't feel just because you're presented with A that you're obligated to do B. Employment law under normal circumstances is very nuanced, but under a pandemic situation is especially so. And your advice, Michael, to be flexible, work through the process, be reasonable, avoid future litigation, and get people back to work safely. So this has been very, very good advice. I know that our viewers have been rather shy today, but if you remember last time, Mike, they posed questions afterward, and you were very, very generous in your time in providing response in our chat side. So I do welcome you to do that again. And as always, we're happy to refer folks and future questions from business people to both you and Kelsey and the team at CCP. Thank you very, very much for your time today. I think what we covered: layoff extensions, return to work, accommodations, the issues of safety, nervousness, and some good advice, SUS, and the emergency wage subsidy, and good advice, good parting wisdom as well. Well, thank you both. I've got a couple of closing comments. Our viewers, I want to thank you for your attention here today. Tomorrow morning, we have the Ontario Minister of Transportation. Her name is Caroline Mulroney, and we are welcoming her back to our podium. It will be virtual this time. We had her here in the fall live. The issue of a new highway, the GTA West Corridor Highway and the Heritage Heights area of Brampton, the issue of two-way all-day go, the issue of more investment in BRT on Queen Street and LRT up to the downtown go will be topics of discussion with the minister tomorrow. Hopefully you can tune into that. Register at bramptonbot.com/in conversation, and that is again a conversation with the Honorable Caroline Mulroney, Ontario Minister of Transportation, 8 o'clock tomorrow morning. You can register at bramptonbot.com. As well, the next expert series, we have two scheduled for next week. On Tuesday the 11th, we have I think it's Tuesday the 11th next week. Yeah, that's right. We've got in the afternoon, starting at 1 o'clock, Renzo Rinaldi from TD talking about small business banking during the pandemic. And on the morning, 8 o'clock of Thursday, which is the 13th. For those of you that are looking at expanding your business, we've got two of the experts from the city, the Commissioner of Planning, also three actually, the Commissioner of Building Permits, Director of Building Permits, and also Development Approvals. Rick Kennard and Alan Parsons and Richard Forward will be joining us next Thursday at 8 a.m. So thank you again for your attention here. We will record this session. It can be found at bramptonbot.com/expert series. If you're looking for other reopening resources, go to bramptonbot.com/reopening resources, and you can see how Brampton BOT members can help one another with PPE, with other advice and material that you need to welcome your employees back and continue to survive through the pandemic and hopefully thrive through it as well. So again, thank you, Kelsey, very much for your attention. Thank you, Michael, and we look forward to seeing you next time here on the Brampton Board of Trade Expert Series.
Thanks, Todd. Thanks, everyone.